Welcome back to the hot seat with Anna. And today we have a lawyer we are going to grill. And her name is Jennifer Romanello of the Romanello and Rodriguez Law, which is an estate planning, probate, and real estate law firm based in Florida. And Jennifer is killing it. So we are going to ask her tough questions to find out a little bit more about her areas of expertise. Welcome, Jennifer.
Thank you so much. Thank you for having me. I'm excited.
Thank you for being here. Jennifer, many business owners, maybe including myself, avoid estate planning because they think it applies only to billionaires when you reach a certain level of income. And it doesn't apply to smaller business owners. So, in your opinion, you've seen it all. At what financial level does estate planning become non-optional?
So, honestly, estate planning stops being optional the moment you have anything to protect. And in Florida, that threshold is lower than most people think. If you own a car, if you have a bank account, if you have children, you need a plan. So the myth that it's only for billionaires is one of the most dangerous misconceptions I see, even millionaires. I've had clients who have as little as just a condo that they really love and they want to protect. So what estate planning really does is it gives you the power to decide who gets your assets, who raises your kids, who makes medical decisions or steps into your shoes to make decisions when you're incapacitated, because there's living documents as well. But without a plan, Florida law decides all of that for you. And it rarely lines up with what you actually wanted. So ultimately, the moment you have someone you love or something you've worked for, estate planning becomes non-optional. So I'm a
Yeah.
big proponent, big fan.
Well, obviously, it would be really awkward if it was otherwise. But let's assume someone is successful entrepreneur, has a successful growing business, and they die without a will. So what
Yeah.
cows can hit their family and also their business in the first 30 days?
The first 30 days without a plan are brutal. So immediately, no one has legal authority to access the bank accounts, the business checking account, the operating funds, they're all frozen. Vendors don't get paid, employees don't know who's in charge. So meanwhile, the family might be grieving, they're fielding calls from creditors. If there's no will, then the estate's going to go through what's called intestate succession. This is Florida law for when you don't have a plan in place. This means that the state's formula is going to dictate who inherits, which might not reflect the owner's wishes at all. So if there's a spouse and children from a prior relationship, Florida law can create a split that the owner never intended, and that surviving spouse probably can't afford. So if none of this usually gets resolved within 30 days, probate typically takes 6 to 12 months minimum. It just depends on the type of probate and the amount of assets. So chaos can start from day one. I've had probates that have gone on for a couple years because there's a lot of difficulty with accessing the business documents, accessing the business accounts. And it's just, if you don't have something in place, there will be chaos.
Thank you. Sounds brutal. Um, Many people also kind of believe that if you have a will, it solves everything, which I know is not true. So, in your experience, what problems can still appear even when someone has a will in place?
Yeah. A last will and testament is a great tool. It's definitely better than nothing, but it's not the end goal. It's not a finish line. It's a starting point. So what people don't realize is that a last will and testament still goes through probate in Florida. It means that it's subject to public record, it takes time, and it costs money. And if assets are titled incorrectly, say a bank account with no beneficiary designation, that's going to get pulled into probate, even if the will says something different. So, beneficiary designations on life insurance or retirement accounts actually will override a last will and testament. But let's say, for example, you have an ex-spouse, it's still listed on your retirement account, which I have had cases like that. They may still inherit regardless of what the will says. So you have to be very careful and proactive with updating beneficiary designations as well as your will. But a will also does nothing for incapacity planning. Let's say you're in a
Mm.
coma. A will doesn't help anyone make decisions for you. You also need what's called a durable power of attorney and healthcare surrogate designations. Those are going to be your living documents that protect you during your life. and then a will would be after you pass away. But a will has gaps. It has gaps. A full comprehensive estate plan encompasses everything during your life as well as after you pass away.
Wow, now I'm worried. Let's talk about procrastination. I know that many people are kind of talking about, I need a will, I need a trust, but they keep putting it off. So let's talk about procrastination. You meet
Mhm.
successful professionals every week, I'm sure. What excuses do people actually use or most often give to you for avoiding estate planning?
Procrastination is going to be one of the biggest hurdles for estate planning, definitely. And I hear excuses all the time. One of the biggest excuses is for young professionals. Is they're saying I'm too young for that, and I find that difficult because when you're a young professional, you're starting to build wealth. You're starting to have families and minor kids. This is the time to start putting things in writing. I work with families that have lost children, uh, lost children, but also lost them, family members at a young age, and age is not going to be guaranteed. So that's a big excuse that I hear. Another one is I don't have enough assets. But again, when you don't have enough assets in place, you're still growing. So it's like one of the things that I've seen is that, like, somebody will have a life insurance policy, but a life insurance policy can be $1 million. If you passed away today, your assets now encompass $1 million. So you have assets, they just might not trigger until you pass away. And another one is, it's too expensive. But the
Mm,
cost of a proper estate plan can be a fraction of what a family will pay to sort out a mess in probate, emotionally and financially. But probate is very costly, and that's going to come out of your pocket. You're just not going to see it. It's going to come out of your estate. But the biggest excuse is always, I've been meaning to do my will. I'll get to it eventually.
mm,
Procrastination, like I said, it's the biggest enemy to estate planning.
mm.
But life doesn't schedule itself around your to-do list. An investment in an estate plan today is nothing compared to what your family pays in probate and potential complex in the future. So it's definitely a worthwhile investment, and it will give you peace of mind.
I'll throw in a personal question then, a cheeky question. I want to see if you're one of those shoemakers with no shoes. You are pretty young still yourself, and I know you
Yeah.
have two children. Do you
Mhm.
have a will and a trust?
I have a full trust plan.
Mhm.
I used to have a will, but I once I had my second child, I finally sat down and I drafted my entire revocable living trust. I have
Mhm.
powers of attorney for my husband and I. I have advanced healthcare directives. I have life insurance policies. I have everything. No, there's still so much more I want to do, but yes, I immediately, as soon as I could, I got myself my revocable trust drafted and ready.
Well, it sounds like you might be worth more dead than alive nowadays. It's amazing.
A little bit with the policies, probably.
So I'm friends with a lot of business owners, and I
Hmm.
see that they spend years building their companies, but then kind of forget succession planning. What
Yeah,
happens to business when the
yeah.
owner suddenly disappears without a plan? It may be they pass away, but also I had a friend who has long-term chronic illness now and's been hospitalized for 3 months and was incapable
Mm-hmm.
of making decisions.
Wow. Yes. That's where with that friend, that's where a durable power of attorney would come into play. Depending on it's first and foremost, it depends on the structure of the business. If there's other, if your friend who's incapacitated doesn't have a business partner, then that's where a power of attorney can be very strong. And especially a durable power of attorney if they're incapacitated, because you can have somebody step into your shoes. Alternatively, a trust. If you have a trust that owns the business, which is a part of adding structuring that protection for your business, your successor trustee can step into your shoes as well. But businesses can fall apart very quickly if you were to pass away or if you were to become incapacitated with no plan in place. That's why succession plans are so key. So you have somebody designated with legal authority to step in and run the business. But again, like if it's a multi-owner business, remaining partners can find themselves forced into a business relationship with the deceased owner's spouse or children, people who may not have an interest or knowledge in the business. But a proper plan would include, buy sell agreements, clear instructions on what happens to the ownership interest, Ideally, a funded mechanism like life insurance. A lot of people do those with their business owners
Mhm.
to make the transition possible. But for some others, you can hold your business interest in a trust. That's a powerful option, and it transfers that pretty seamlessly at death without probate. And like I said, the successor trustee can step in. So there are definitely a couple ways to go about it, but definitely needing something in writing is key.
Thank you. Well,
Mhm.
you mentioned probate a couple of
Yeah.
times. I'm not an
Oh yeah.
attorney, so to me,
Of
probate sounds
course.
like a really boring legal term. So why does probate become expensive, slow, and stressful for
Yeah.
families?
Yeah. Probate is the process of administering your assets through the court system after you've passed away. If you only have a will, like I said, wills don't avoid probate. Trust can avoid probate, but if you only have a will, that's still likely going to end up in probate if you don't have everything properly designated. But probate it's a court procedure. It takes time and it costs money. Florida law sets out a fee structure tied to the size of the estate. But regardless of how your attorney bills, probate is rarely cheap. And the larger the estate, the more exposure there is. So the process requires notice to creditors, which has a mandatory waiting period. If there are disputes amongst heirs, even minor ones, it can drag out for years. If there's creditors that come in, that can also extend the process. The entire proceeding is also subject to public record, meaning that anybody can look up what you own. They can look up how your assets were, designated to go. It keeps it out in the open, and a lot of people don't like that, which is why trusts are very popular because they can remain private. So, for families who are already grieving, trying to navigate a court procedure such as probate, dealing with court filings, legal timelines, it's genuinely can be painful and it's stressful. And most of this can be avoided entirely with a well-structured estate plan in place, having your assets pass outside of probate.
Interesting. You kind of part answered my next question, and it's kind of more of a personal question because I
Hmm.
went through creating my trust and my will a couple of years ago, and I was surprised as a European to hear that the lawyer suggested we put my property, my house, in my trust. So I
Hmm.
know that real estate owners often hold property in their personal name, not in a trust.
Hmm.
So
Yeah.
I kind of touched based on it, but what risks show up when investors fail to structure properly ownership correctly?
I always tell my clients that if you are planning to purchase property in the future, come talk to me, any other
Hmm.
estate planner, but talk to somebody because there are huge risks. If a property is held in your personal name and someone slips and falls in that property, they can come after your personal assets, your home, your savings, everything. Proper
Hmm.
structuring, typically through like an LLC, that's going to create that liability barrier. And what we do is we connect that with the trust to make sure that you have limited liability, but we still try to avoid probate as best as possible by having the trust own that LLC. So from an estate planning perspective, property held in your personal name goes through probate when you die. But which that's going to mean delays, it's going to mean costs, it's going to mean public exposure. But if you own property, another issue, if you own property in multiple states, because oftentimes investors own properties all over the country, it's going to
Hmm.
get worse because your family may have to open probate in every state where you own real estate if that property is solely in your name. The
Okay.
solution is, like I said, to title property through a trust or an entity that avoids that problem. And in Florida specifically, we also have homestead rules that affect how primary
Mm.
residence can be devised, and people get tripped up with that constantly. So we have to properly structure it.
Wow.
Mhm.
Well, it sounds like you often meet families during emotional moments after someone passes away as part of a probate as well. What legal
Mhm.
mistakes create the most conflict between
Mhm.
relatives? Because there are movies, that go around this subject, how someone passes away and then relatives fall out, families start
Yeah.
arguing. So, what kind of legal mistakes lead to or add to those conflicts?
I always like to think of probate as divorce in family law, but after you've passed away, and that's where conflict can arise. Unequal or unclear distributions are like top of the list. When you have unequal distributions, if a parent gives one child more than another, even if it's for good reasons, without explaining it in writing, it almost always creates a conflict. Second biggest is going to be like outdated documents. If a will was drafted 20 years ago that names a deceased person as the personal representative, or it's commonly called the executor in a lot of other states, that does not, and it doesn't account for new children or divorce. It's just a recipe for disputes. When you have major changes in your life and you haven't updated those documents in a lot of years, you're going to have potential conflict. Blended families, those are particularly vulnerable. You could potentially accidentally disinherit certain people,
Mhm.
but they also might have competing interests for, with your property, with your funds.
Mhm.
Informal promises is another one. So I've had clients who are saying, well, my relative said that I was going to get all of that, but if it's
Mhm.
not in writing and it's not documented, it could potentially create a legal battle if they want to pursue that. So
Mhm.
clear, current, properly executed documents are going to be the best conflict prevention tool there is.
So every time you purchase, sell a property, make an investment into anything substantial like a car or, get married, get divorced, have a child, that's the point in your life where you really need to think
Yeah.
about updating those documents. Okay,
And
great.
that's a question I get is how often should I update my trust? And it's major life changes or, or purchasing property, everything you just said.
Perfect.
Mhm.
So let's say a married couple with kids and a small business walks into your office today. What three documents must they leave with? So what are the
Yeah.
three
Yeah.
must-have documents they need to have?
And I've touched on all of them. A married couple, a joint revocable living trust. This is
Mhm.
the foundation, and it's commonly used now as a substitute to last will and testaments for all the reasons that I've already explained. Avoid probate avoidance. It can hold their assets, can avoid probate, gives clear instructions for what happens to a business and family assets when one or both spouses pass away or if they became incapacitated, which then goes into your second document. It's going to be a durable power of attorney. I think this is one of the most powerful documents that you can provide to your loved ones, and it's during your life. I think each spouse needs this. If you're in a real estate transaction, you have those powers, and somebody's incapacitated, that person can now sign those contracts for you. Or they can continue your business if you are incapacitated, so your business doesn't fall apart. And third is going to be healthcare documents. And we do all of these in like a comprehensive packet, but it's because they're so key. Healthcare surrogates and a living will, it's different than a last will and testament. This is where you're going to name your end of life decisions, who can access your medical information or make medical decisions for you if you're incapacitated. That's going to help avoid both that and a durable power of attorney, or could avoid a need for a legal guardian.
Mhm.
If they walk out with those three, they're going to be meaningfully protected.
Perfect. And last question, you'll be happy to
Hmm.
hear. So
Hmm.
a lot of people are listening to this now. So, I'm sure they are very impressed with your level of expertise and start thinking about, wow, actually, maybe I need something. But
Hmm.
again, going back to that question of procrastination, many people are like, I'm healthy, I'm successful, I'm young. They may not have children yet. So estate planning can wait. What would you
Hmm.
say to change their mind today and get them to go and get a will, a trust, healthcare
Yeah.
documents?
I say this all the time. Estate planning is not about preparing to pass away. It's about protecting the life you've already built, giving yourself peace of mind, and leaving a gift to your loved ones. It's taking the unknown away from your loved ones, and it's the biggest gift. Oftentimes, the people that come to me are, my probate clients who never want to have their family members go through probate. So a plan ensures that what you've built goes where you want it to go on your terms, and so, what I've seen, the people you think that have time are the ones whose families end up in my office after an unexpected accident or diagnosis, trying to sort out the mess that could have been solved with an estate plan in place. And in
Mhm.
Florida, passing away without a plan means that the state's going to write that plan for you. And it might not reflect what you or your family, your business, your values, whatever it is that's important to you. The state's law is not necessarily going to reflect how you want it to go. Maybe you don't get along with heir that would be taking under, you're under Florida law. You don't have a good relationship with somebody, and now they're the ones that are going to take. So an estate plan isn't a document that you're creating because you're planning to pass away. It's something that you create because you're planning to live and because the people you love deserve that protection. It's going to give you and your loved ones peace of mind.
A personal question, actually, because I was asked this question and I still don't know whether it's right or wrong to do it or not. So, but you name a couple of people. Once you prepare these documents, you name a couple of people for different positions in your
Hmm.
document.
Yeah.
You actually go ahead and proactively inform these people that say in the event
Yeah.
of emergency, if you pass away, something happens, that's the role you're asking. Is it polite to ask them before you nominate them and actually
Yeah.
inform them? Because I have two people I discussed it with, and I have one person in my document pack who doesn't know that they will, inherit certain things and be responsible for certain things. So what's
Hmm.
your advice? Is it best to discuss
Yeah.
it before you even nominate them, or how would you handle that?
Absolutely. It's kind of twofold because one, I always like to layer. I don't like to leave anything to the unknown. So I like to put multiple backups. I always tell my clients at least two options as backups.
Mhm,
Three, I think I put four or five in mine because I just did not want any room for it going to court.
mhm,
But I definitely think that it's a courtesy to discuss these things with some of the people that, they would be fiduciaries is what's the term. They're going to be people that are in that capacity that are acting for the best interest of your trust or your best interest of yourself. If it's those incapacity, documents such as power of attorney, advanced healthcare directives. And with that, they need to know what they're getting themselves into. Being a trustee for a trust, it can be like a job. And it can be very complicated, especially if it's a layered trust that has a lot of, longevity to it.
mhm.
If it's a very simple trust, it's not as complicated. But yes, if you're also naming guardians for minor children, it's best to discuss that with them. See
Oh, yes.
if that's something that they're willing to take on because that's a disruption to their lives. It could be considered. So I think that yes, I think it's important to have that discussion with those people that you're trying to name, but at the
Mhm,
same time, layers. Adding multiple backups of people that you anticipate if you don't want to have that conversation, then have backups for people that you would trust to handle those situations for each
mhm,
one. So in assuming that the first choice might not accept. And so always accept, like imagine that all the second, third, fourth options,
mhm.
would you be trusting of them just as equal as your first choice?
Thank you. That's a really interesting
Mhm.
way of thinking. I don't think I have two or even three layers of backups. I think I have one
Mm,
backup, and actually, I probably need to update my documents
yeah.
now because that backup is not with us anymore.
Yeah.
So, mm,
Especially if that person might be older than you, and if these documents you're not planning to pass away. So if you're older when these documents actually take effect,
mm,
maybe if it's somebody that's older than you, think about somebody who you trust that might be younger and would
mhm,
survive you as well.
yeah. Mm.
Yeah,
Well, I'm planning to live until I'm 116, so I'm going to survive
yeah,
everybody. That's
that's
my goal.
perfect. Exactly.
I'm working on it to be able to afford to live until I'm 116. Someone
Yeah,
yesterday told me, I hope I will live till 100 years old. And I said, have you
yeah.
discussed it with your financial planner? Can you afford to live till you're
Does your retirement last that long? Yeah.
exactly, exactly. Because
Yeah,
it's also about the quality of life, right? It's not just about
yeah,
the length of your life. Well, thanks so
exactly.
much. I have a couple of personal
Yeah,
questions for you, if you don't mind. I know
sure.
it's
Of
unexpected,
course.
but we want to know a little bit more about you. I know
Absolutely.
that, you have a family, you have two little ones. I have
Mm-hmm.
one who just came home from Korea. Whoop, whoop.
Yes,
I mean, and three dogs in the house. How
I
do you
do.
survive? Like, how, tell us about your family
Oh,
and what they mean
uh,
in your life.
oh my gosh. I do everything for my family. I started my business 5 years ago with my long-term friend, Natalie Rodriguez. Her and I didn't plan for this, but 2020 hit and we decided that we wanted to take control of our lives.
Mhm,
We wanted to get ourselves financially stable for the future. And we wanted to build everything that we could imagine within this business. And now it's been 5 years and there would be absolutely no turning back. I could never see myself not owning this firm. And the only reason I do it is for my family. I always had that mindset of like I always wanted to be a mom, and we started this before we had children. And I was like, I want to be able to have the flexibility, the financial stability, everything, and give everything that I can to my children and my dogs. But yes, I have quite the household, but it's amazing. I have two boys, and I can they're only babies. They're taught two and 9 months, and ooh, boys. I only grew up in a household with a sister, so it's definitely a little different. But I love it. I love it.
No, Natalie
It's what
has
gives me purpose.
right? So you have some future potentially family reunions with Natalie's daughter because Natalie Scotty is how old? She's just a
She just turned one. Yeah,
oh my
yeah.
God, already a year old. Yeah.
I
So
know. I
nice.
know. Yeah, we're very blessed. Yeah.
Congratulations. How
Thank
did
you.
you choose this area of law? Usually
Yeah.
younger attorneys, younger lawyers go into family law. That's my observation. People start with
Yeah.
immigration because they think it's easy. Then
Hmm.
actually it turns out, I have a lot of clients who are lawyers, so I see that evolvement of people, immigration, that's easy. And
Yeah.
then many people move into family law. And actually, I see it
Hmm.
happening with judges as well. They get assigned to family
Yeah.
courts as one of their first assignments, and then 2 years on, they move
Hmm.
on. So, how did you choose estate planning? Why? Estate planning,
Yeah.
probate, real estate?
So I actually had background in family law. It's kind of where I got my start. But family law often, the firms that I worked at actually also did estate planning and probate. And I found myself much more drawn to those areas of practices. They're
Mhm.
positive. I mean, and probate, even though it can be sad, and like I mentioned earlier, it's kind of like the divorce between family members, it's also very rewarding because you're even with estate planning, they're difficult conversations. All of it surrounds this idea of passing away, either of a loved one or yourself. And you get the opportunity to, be that empathetic, person to walk them through one of the most difficult times in their life or the most difficult conversations in their life to think about, the end of their life. And it's really rewarding. I have never been a very litigation heavy person. We handle some litigation when it comes to probate, but when it comes to arguing in court daily, I never saw that for myself, and Natalie didn't really either, even though she does have litigation experience. We wanted something that was more in line with what we're doing. It's giving people positive experiences, walking them through difficult times, but it just is a meaningful area of law for both of us that we both were drawn to. And I wouldn't change it. And now we've just expanded to real estate, which we're very excited. We are able to do real estate transactions, closings, and that's just been a natural segue. We got licensed several years ago, and now we're bringing on a team member finally that's going to be able to support us in that. And it's just a natural segue. With all of these areas, estate planning lines up with probate. Probate usually has properties that need selling, and vice versa with estate planning. Those people are usually buying and selling properties, adding them to their plans, and they all just have this natural connection, and we're really looking forward to that new extension of our firm.
Awesome. Sounds really exciting. I'm looking forward to it for you.
Yeah,
Jennifer, tell us a little bit about yourself. Something no one
yeah.
else knows. Let's
Oh.
take those skeletons out of your closet. Something maybe your husband
No
doesn't
one
know or your
knows.
clients don't know. Or alternative, I'll give you a way out. Tell us
Hmm.
about your worst case that you ever had, worst client case. It doesn't need to be a difficult
Yeah.
client, but maybe something where it was so complicated that you felt like almost walking away.
Well, well, I mean, I don't have. I'm trying to think of something about myself. Well, I'll tell you a fun fact about myself of something that I used to be. I danced my entire life, but
Mhm.
I used to do what's called clogging. It's
Oh,
like a tap dancing. I did it for several years. It's a lot of people always assume that it's like the wooden shoes or it's like an
mhm.
Irish dancing, but it's actually like a tap dance. But it has extra layers of metal to it. And I used to
Mhm.
do that with a local group, and we used to perform at like events all over Davie, Plantation, all over Broward County.
Oh,
People know
wow.
that, but it's just something that was so long ago. So but yeah, I grew up a dancer my entire life. I did team sports. I also ran cross country. So especially cross country, I take that still to this day. I used to run long distances. Now I'm injured, so can't be doing that so much anymore. But I've always taken long distance as a mental state for me because I've always had to mentally prepare for the long run. And so even with my business, I knew that it was going to take so, especially starting so young, I was like, it's going to take several years, but my gosh, it's been worth it because we stuck with it, and it's patience, and it's it's just that structure that you need to go the long distance. And then worst case where walked away, we've had cases where some of the most difficult ones are just when we don't have like good client communication, when they don't really want to be involved. They think
Mm,
that this can just kind of be done. So I've had cases where, we can't proceed if we don't get client cooperation.
mhm.
Those are honestly the most difficult because it's a relationship. When we enter into an attorney-client relationship, there has to be a level of trust and cooperation. That's going to be some of the hardest. Emotionally, we've handled probates where it's been young children who've passed away. We have had a few, and those just hit the heart.
Yeah.
And but those there's nothing really you can do but just support the family and walk them through it. But yeah, not we didn't walk away from those. We handled those, but those can be really difficult too.
Yeah, I can imagine.
Yeah, yeah,
Well, thanks so much for being with us today, Jennifer.
yeah.
Jennifer's a
Thank you.
dancing lawyer. So if you want someone who is fun, as well as super professional and experienced, and I know
Thank
that you have a very fresh approach to, approaching law client relationships, which always sets the younger lawyers off, distinguishes them from someone who is maybe on the older side and is still very traditional. I
you.
love working with young professionals. That's my passion. I feel it's
Yeah.
always more fun. They know all the latest trends. They are still very alert, curious, interested. And I know Jennifer personally, so super highly recommend her.
Yeah.
I know Natalie, know
Same.
Jennifer, an amazing power team, R&R. So R, the dance lawyers.
And we couldn't do it without the Lao Lao support because we have our team member Tiffany with you, and she's amazing and she's integral to our entire operation. So we're so grateful for you and on our relationship with you.
Thanks so much, Jennifer. Nice speaking to you. And guys, I see you next time. I'm interviewing an amazing secret guest. It will be mind-blowing. I can't wait.
Thank you.
Bye.